This law, the Fair Labor Standards Act, has been with us for 80 years now. In the last roughly 5 years, since 2009, the Department of Labor has extracted $1.3 billion from people who didn't know what they were doing. That works out to roughly $250 million a year. In the Marcellus shale work, it's been around $4.5 million in the last couple of years, and I can have to update the slide. You have to add another $250,000 to that, because last week I resolved a case for a contractor that's going to cost them about $250,000 to get out from underneath an audit. Why are people making the mistakes that are costing them money? It typically stems from what's called misclassification. There is a common misperception out there that if I pay my employee a salary, I do not have to pay him or her overtime. And while it is true that all exempt employees are salaried, not all salaried employees are exempt. One of the classic cases, the one that I just resolved, is the first bullet point on this page. Let's just take our crew chiefs, working foremen they were, and we'll, instead of paying them overtime at an hourly rate, which tends to, their income fluctuates, we'll take what they earned last year, we'll convert that into a salary, and then they'll get a steady paycheck for the entire year. Unless that individual actually meets the definition for exemption, he or she is not going to be exempt. You have to meet the regulatory exceptions, exemptions as they're called, in order to be truly exempt from overtime. And recognize that the default position of the Department of Labor and the state agencies which enforce their own laws, the default position is that everybody should be paid overtime. You need to demonstrate to me why this employee is not eligible for overtime. The two common areas where employees are misclassified are in the executive exemption and the administrative exemption, and we'll take a brief tour through those here. The Fair Labor Standards Act exempts from the requirement to pay overtime what's called employees employed in a bona fide executive capacity, and that requires certain things. The salary requirement is only $455 a week. Very few people fall short of that, but here's where they get messed up. The primary duty has to be management of the enterprise, and the employee must customarily and regularly direct the work of 2 or more employees. And there are two elements to that requirement. One is obviously 2 or more, but the other is customarily and regularly direct. And then they give some indicia of managerial authority, hiring or firing, or the effective recommendation of actions such as that. All of those things have to be met before the employee will be considered to be exempt. This part of the regulation sort of restates some of those things and gives some examples. We don't really have to spend a lot of time on it, but customarily and regularly, as I've highlighted up there, are the keys. Now, the Pennsylvania Code, Pennsylvania has its own statute, overtime statute. It's called the Pennsylvania Minimum Wage Act. Pennsylvania Code, the Bureau of Labor Law Compliance, has adopted a very similar definition for exempt executive employees in Pennsylvania. One of the things that we'll touch on briefly in a moment, every state that I'm aware of, certainly every state in this area, in this region, has its own overtime requirements. They can be, and frequently are, different than the Fair Labor Standards Act. The Fair Labor Standards Act is one of the few federal statutes that allows the states to do more. The Fair Labor Standards Act sets the floor. States are allowed to raise that floor. You've heard of states that have passed minimum wage laws that are above $7.25 an hour. That's one of the features of the Fair Labor Standards Act, that they can do that. You have to be careful wherever you're working that you're complying not only with the state law or the federal law, but with the state law as well. Administrative employees are also defined in the federal law, federal regulations. They have to be compensated on a salary or fee basis, again, $455 a week. They have to have a primary duty that's office or non-manual, so you can't have your assistant foreman in the trench being an administrative, meeting the administrative exemption. And this is the key where everybody gets messed up. Exercise of discretion and independent judgment with respect to matters of significance. Your payroll clerk, in all likelihood, is not an exempt employee unless he or she has some ability to exercise independent judgment and discretion in terms of managing the payroll. Just because he or she is paid a salary, again, does not make him or her exempt. And the regulation goes on to list various things that are indicia of the exercise of discretion. They're listed here on the slide. Authority to formulate, affect, interpret, or implement management policies or operating practices, carrying out major assignments and conducting the operations of the business, performing work that affects the business operations to a substantial degree, even if the employee's assignments are related to operation of a particular segment of the business. And there's more on the next slide. Most employers run afoul of the exercise of discretion standard. Even though they pay the salary and they require long hours of work, but that employee doesn't exercise the discretion. In addition, there is a requirement in Pennsylvania, and this applies both to the managerial exemption and to the administrative exemption. Pennsylvania is a state that has higher standards than does the federal government. And it's in item number 4 here, more than 20%. If your working foreman or your administrative assistant spends more than 20% of his or her time doing non-exempt work, under Pennsylvania law, that employee is not exempt and overtime must be paid. In contrast, federal law requires 50%. So there is a distinction between state and federal law being more generous to the employer than state law. And many people run afoul of the differences between state and federal law. Also, primary duty, which is a requirement under both state and federal law, means that the performance of the exempt work must be the principal function of the job. And this is the rule of thumb under federal law. Again, under state law, Pennsylvania law, it's 20%. And other states may have different requirements. So if you're working in many states, different states, you need to make sure that you have an understanding of what the rules are in the particular state you're working in. So a lot of people make the mistake of thinking that, well, I have a job description that indicates that the employee is exempt. That should be good enough. The Department of Labor won't even ask you for your job descriptions if they're doing an audit. They want to know the actual duties. If you've ever been involved in a DOL wage and hour audit, you know that they meet with you or the client. They require some information, turnover of payroll records. Then they'll place phone calls to people who work for you. They'll ask for contact information, and they'll call people and ask them what they do. And they make their determination as to whether someone is appropriately classified as exempt on the basis of the answers they get to the questions that they ask during the interview. So again, as I've indicated, you've got to make sure that your job descriptions actually describe the work that is being done, and you can't rely on them as a defense to a wage hour audit. As I've indicated already, that non-managerial and non-administrative work can't exceed 20% of the employee's time in Pennsylvania, and also that other states may have different laws, and you need to be cognizant of them. So what do you do to avoid this dilemma? The time to take a look at what you're actually doing is not when the Department of Labor sends you the letter that says they want to come in and look around. You really need to sit down with your appropriate HR people or whomever it might be, take a look at who we've got classified as exempt, make sure we understand what those people are actually doing, and then do a analysis of those functions as they relate to or compare with the federal requirements for exemption and the state requirements for exemption. Remember, again, it's the actual duties that are being tested here, not the job description. You also have to make sure for your overtime calculations that you are including all of the items that need to be included. It is very common in the construction business to offer production bonuses to employees. Those items, if it's a non-exempt employee, the production bonus must be included in what's called the regular rate. And the regular rate is not the rate per hour. It is the that may be set forth in your labor contract or your employment agreement. It's a term of art under the Fair Labor Standards Act. It's been adopted by all the states. It essentially requires that you look in a week, what was the total remuneration for work, divide that by the total number of hours worked, that's the regular rate. And then on top of that, every hour over 40 for a non-exempt employee must be paid at time and a half of that regular rate. So in a production bonus situation, that may not be calculable until the end of the job or the end of a sequence of the job. You have to look at that and prorate it back over the weeks that it was earned. Take a look at those weeks, see which week hours over 40 were worked, add it into the regular rate for that week, and pay the differential in overtime. Excluded items, there are also several. A per diem is an example, if the per diem is not based on hours worked. If it is truly a per diem, I've got employees who are away from home on a job, I'm paying them $100 a day for food and lodging, and they get that whether they work or not, that can be excluded from the regular rate. Their regulations governing the calculations are set forth at the citation set forth there. They are tedious to review. They're full of examples. They are important things to understand if you're going to be employing people. And finally, if it's broke, fix it. Once you do what I've suggested you do in tip 4, which is do an analysis of your exempt employees, make sure that they are doing what their job descriptions say, or develop job descriptions that say what they actually do. If you find problems, fix it. If you fix it yourself going forward, you can do it on the sly, so to speak, and maybe no one will ever be the wiser. The Department of Labor, for your first offense, will allow you to settle up for just what you owe, and they'll tell you to go and sin no more, but if they catch you doing it again, there's civil fines and potential criminal penalties. The most interesting aspect of this from a legal perspective is that when the Department of Labor comes in and finds a violation and tells you what you owe your employee, and you offer to pay that employee that amount, the employee does not have to accept it. The employee can seek legal counsel and sue you for the other remedies that are available under the Act, which are, from the employee's perspective, the liquidated damages that are typically available, which is double the amount that's unpaid. And of course, you get to pay his lawyer for making you hurt. The Class Action Fair Labor Standards Act, coupled with a Class Action State Minimum Wage Act case, very lucrative for the plaintiff's bar. You've read about the cases that are out there. The time to fix it is before it gets to that point, because you don't want to be involved in the class action discovery, let alone the actual trial of the case. So if you find something that's wrong, fix it. You cannot legally get an employee, even if you find something wrong and say, hey, we want to make it right, please, here's the money we owe you, sign this release, that release won't be valid. The only way to get a valid release in a wage case is either through the Department of Labor settlement proceedings or through settling a case in court. So you can make the payment. That doesn't insulate you from future litigation. It does, however, obviously it acts as a set-off, and there's arguments to be made that since I've settled up, there's no claim left. But those are the ones you're making in court while you're already there.